So let's now change gears and discuss a matter that has elicited a great debate in the country. A court ruling re-allowing the reintroduction of some guidelines on abortion has generated a heated and mixed debate among the public. So did the court allow abortion through the back door, or is it a case of misunderstanding? Well, to help us understand this issue, we have in the studio with us Evelyn Opondo, who is the Regional Director from the Center for Reproductive Rights, Professor Jaldesa Guyo, a medic, and Dr. Stephen Karanja, who will be speaking to us on this matter in studio. But before that, on our top poll question this morning, we're asking you, do you support the reintroduction of some guidelines on abortion as ordered by the court? Do you support the reintroduction of the guidelines on safe abortion as ordered by the court? Do speak to us. Our hashtag is KTN News Center. You can also speak to me at Michelle Ngele or at KTN News Kenya. We'll be sampling your thoughts and comments in the course of this live broadcast. All right, and in studio with us, as I mentioned, Professor Jaldesa Guyo, Evelyn Opondo, and Dr. Stephen Karanja. Ladies and gentlemen, many thanks for making time for us on News Center this morning. I'd like to begin with your reactions, each of your reactions stemming from that verdict by the court. Professor Jaldesa.
Number one, I think I want to state clearly that abortion is a very common issue in this country, with about 500,000 women undergoing induced abortion every year. And that abortion contributes to about 20% of maternal deaths in this country, and more so the death from unsafe abortion. As an obstetrician gynecologist and reproductive rights advocate for women, I was shocked when the Director of Medical Service withdrew the standards and guidelines. It was very unfortunate because he was taking away the rights from the women and the providers who are offering the services to the women.
Right.
The good thing about the judgment was that it had actually realized that, yes, women have the right for services, and that the standards and guidelines should be returned as it was or reinstated, and that it was it was good news for any person who cares about women.
Evelyn, other than declaring or just emphasizing that abortion remains illegal in the country, they did reinstate these rules. Let's talk to Kenyans about these rules stemming from the, what is it called? Is it the Maputo Protocol that Kenya is signatory to? What do these guidelines entail?
Thank you very much. I think, first of all, to state that we welcome the judgment, and I think it's important to give the viewers some background to what was taken to court so that we are all on the same page. Now, in 2010, Kenya adopted a new constitution, which for the first time provided for circumstances under which abortion can be is legal within the constitution itself. And the constitution provides that if, in the opinion of a trained health professional, a pregnant woman's life or health is in danger, or in case of emergency, that pregnancy can be terminated. Now, in 2012, the Ministry of Health developed standards and guidelines for reducing unsafe abortion. And a year later, these standards and guidelines had been withdrawn arbitrarily. And the ministry then proceeded to issue a directive to all medical providers not to attend any training whatsoever on abortion, and that if they did, they would face dire legal and professional consequences. Now, this is where the case is stemming from. This is what we were aggrieved with. And as the Center for Reproductive Rights, we then went to court. And in this particular case, we represented FIDA Kenya. We represented two community-based advocates who were bringing to the fore the experience of women who are living in informal settlement areas with unsafe abortion. We also represented a minor who was defiled at 14 years of age. She could not access post-rape care. She got pregnant. She then ended up in a Quacks clinic where she procured unsafe abortion. Even after doing that, she could not access quality and timely post-abortion care, which was linked to the actions of the Ministry of Health. And indeed, on 12th June, the High Court, a 5-judge bench, issued their decision. And in this decision, the High Court affirmed that the Constitution provides for circumstances under which abortion is allowed. The court then also went ahead to say that the actions of the Ministry of Health violated the rights of women and girls. Right. The court also said that the actions violated the right of health providers and listed all those rights. The court affirmed that indeed the medical providers, professionals that can provide this service, include mid-level providers, nurses, midwives, doctors, and clinical officers. The court then also made a finding that this minor who had could not access post-abortion care and ended up dying as a result of kidney problems last year, that her rights had been violated, and the court asked that the government compensate the mother who was representing
Absolutely,
her.
with 3 million shillings. It is findings, those findings of the court that have become rather controversial in the country. Dr. Karanja, speak to us about what Evelyn talks about, first of all, that a trained medical provider, under the instruction of a trained medical provider, then an abortion can be procured. But Kenyans are now asking, has the court then allowed abortion through the back door? Because it is allowing abortion for mothers who get pregnant as a result of sexual violence or rape.
I think there is a major misunderstanding throughout the country. And I think unless this country takes a deep breath first to ask themselves, can the Ministry of Health withdraw guidelines frivolous? It is not true. I know the background why the ministry withdrew the guidelines.
Why is that?
Because the guidelines were made by the abortion lobby, and this country cannot be run by the abortion lobby. Number two, a decision of a 5-bench judge cannot pretend to change the national constitution. They may say a lot of blah, 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 but that's what it ends up to be. The constitution of this country is actually the will of the people. And even as people are making this will, every Kenyan still remembers that it was said that 20% of the constitution had a problem that was going to be sorted out later. One of these problems was that minor thing of a statement of fact that Article 26(4) of the Kenya Constitution says that abortion is not permitted. And what the Constitution allows is the opinion of a trained professional. A trained professional is somebody who can make an opinion in medical matters, from taking history, examination, doing other tests, and then making an opinion. The only universal person who can make medical opinions are trained doctors. Any other person, including sweepers, including drivers, can be taught a skill of doing something.
But like you mentioned, Article 26 of the Constitution, the same Constitution you state is the will of the people, does not only state under the opinion of a trained health professional, it also states that it can be procured or permitted under the need for emergency treatment, or the health of the mother is in danger, or if permitted by any other written law. And the Maputo Protocol is one that Kenya is signatory to.
Correct. And I would wish to correct here. The Maputo Protocol is written in black and white. Article 14 of the Maputo Protocol, the Kenyan government refused to sign. It is not a signatory on Maputo Protocol Article 14, which actually talks about abortion. Because Kenya would not have done that. And anybody who has quoted the Maputo Protocol, that is deceitful. Because the Maputo Protocol, we can all read it even as it stands today.
All right, let's hold it there for a moment and bring in Professor Guyo. You have quite a lot to say about what Dr. Karanja says.
Yes, I respect my colleague. We are both gynecologists, and I respect his views, but his views is not a reflection of the reality on the ground. In that, yes, the Constitution does not allow abortion on demand. That somebody can just walk in. It happens in many countries in the world that women have no reason to explain why they require the abortion. But here, there's a caveat. And the caveat is you cannot ask for abortion on demand, but if according to the medical professional who is providing the services at whatever level, we're not talking about the sweepers and the drivers. We're talking of people who have been trained to offer the services at professional level, and that's what the court ruling was, according to the Kenya Health Act. That is what the people mentioned by Evelyn. And the reason why it was so was because in many parts of this country, the health providers are not equitably distributed. There are many places where there are no doctors, and the only available people are the nurses and the doctor and the clinical officers. And if they're the ones who are in that place, in the remote parts of the country, then that person should be the one to provide and not send the person or deny the person treatment. But in terms of Maputo Protocol, of course, that was done 15 years ago,
Right.
2003. And the idea is how Kenya should improve on the reservation on the restrictions on abortion. Many countries in the region, in Africa region, I also work with the International Federation of Obstetrics and Gynecology at the regional level. And many countries have realized that 20% of maternal deaths occurring in a country is not something that you can ignore. And these 20% are women who are young and healthy and in the prime of their life. We cannot just allow their lives and health to be done away with just because of restrictive law, because some categories of the community are against the rights of women.
Well, let's discuss this a bit, Professor, and take the case of the 15-year-old minor that was in this particular petition. What happens in the case where one is a victim of sexual violence or is a victim of rape and has fallen pregnant, but there are no health implications really on the mother and the child? Can they still go ahead and procure abortion in the on-demand?
The issue is simple. Do you want to keep the abortion? Does it bother you? If you are enjoying the pregnancy and keep it, it's nice. Nobody will ask you to terminate it. But if it disturbs somebody, it gives you mental anguish. It gives you psychological disturbance. It gives you health issues. Then you should not be allowed to die because we wanted you to carry the pregnancy.
All right. This is where the debate gets more complicated. Evelyn, your thoughts on this?
Yes.
Just a moment, Dr. Karanja.
I think first it's important to say that Kenya is a signatory to the Maputo Protocol. Now, Kenya has made a reservation on Article 14(2)(c) of the Maputo Protocol that speaks on abortion. But the court indeed reflected on this. And the court says that whatever reservation we made does not take away what is in the Constitution. That the grounds under which abortion is permitted in the Constitution remains. And in fact, the court looked at both Maputo Protocol against our Constitution and say there's great alignment in that. And so the reservation does not take that away. Secondly, on the issue of rape, as Professor Jaldesa has explained, the court indeed went ahead to explain what health is. And the court reflected on the Health Act, which has now defined health to include not only physical, but also mental and social well-being. And the court said that if a rape survivor is pregnant out of that rape, and a medical provider determines that this pregnancy affects their health, whether it's mental or physical health, then that pregnancy can be terminated under the law. The other thing that I want to just reflect on, Dr. Karanja said here that the court was trying to introduce abortion through the back door. And you correctly read the Constitution. You see, the problem is that there are several people who are reading the Constitution and only stopping at abortion is not permitted. You have to read the entire article, and you have to read the whole of Article 26 in its entirety, so that you know what the law permits. And indeed, the law permits abortion under those circumstances. And it's not right to say that Kenyans don't want abortion. Kenyans, these were issues that were raised at the referendum. Kenyans voted, especially on the issue of abortion. And we had 67% of Kenyans that supported the Constitution. The Constitution remains what it was. And these arguments that we are hearing now, these are not new. Even before the referendum, we had the arguments that mortuary attendants were going to provide abortion under this new constitution. We also had that, anybody, even a cleaner in the health facility, was going to provide these services. We do not have any evidence 9 years down the road to show that any mortuary attendant has given anybody abortion or any cleaner. And so this fear mongering, it is not new, but we must know that when we adopted the Constitution, this matter was settled. And we cannot keep going back and reopening this. The Constitution is the supreme law of the land. It is what it is, and we will deal with it as it is, the basis of our arguments. We all have different faith, but the Constitution is the neutral ground under which we all subject ourselves.
All right, Dr. Karanja, just before I come to you, Professor Dr. Karanja, let's think about this and the fact that doctors and trained medical professionals, at the end of the day, adhere to a certain code of ethics, which according to their profession, they cannot misuse.
Correct. And it is wrong. And I think that when people are on a national TV like KTN, I think we need to speak a truth that is verifiable. Can somebody quote the Maputo Protocol? No. Kenya is a signatory on other things in the Maputo Protocol, but on matters of abortion, it has reserved. Is that true or false? It is true, and therefore, on matters of abortion, Maputo Protocol does not count. Okay? Number two, there was a girl who was raped, and Madame here has brought it very well. It is extremely sad that a lady was raped in this country. And I still say that anybody who rapes any woman, remember, being raped is forever. Nobody can undo raping of any woman. But I can also tell people, as an old gynecologist, that aborting this woman who has already been injured forever is double tragedy.
What about the state of her mental health, sir?
It's extremely important. And indeed, rape makes it worse. But on top of that, abortion per se has consequences. And one of the known consequences on 99.4%, and there are thousands of papers on this, of abortions, is the mental effects on any woman. The physical effects may be so, but there is something here I want to say, and it is not clear yet. The Kenya Constitution has not changed. The Kenya Constitution says that the women who may have abortion, it is a result of an opinion. They cannot decide themselves. It has to be the opinion of a trained medical professional.
Professor Guyo, please come in.
I think, let's put it this way. Number one, yes, abortion in countries like US, in countries all over Europe, when done and done safely, it's a very, very safe procedure. In fact, literature has it that it is as safe as an injection of penicillin.
Well, Dr. Karanja talks about the mental effect later on.
I'll come to it. It is safer than an injection of penicillin that people get in dispensaries and health centers.
Right.
The issue of mental or psychological disturbance is the indoctrination, the inculcation by the churches and the church-inclined people. But when people are told that it's your right and your choice, and they live that way, and they made the decision based on that knowledge, then they have just exercised their freedom. It's just like waking up and going to work. So it has no mental complication whatsoever. It is just that people, when colleagues like Karanja and others keep on telling them that you're committing sin, you're going to be going to hell and whatever, then somebody, or that you're going to, it's a very dangerous thing, people live in fear. And that's where the origin of the psychological issues come in. But the issue of carrying a pregnancy, unwanted pregnancy, is much more disturbing. That a woman who decides that this is terrible will do whatever is possible. And that's why we have these issues of high maternal mortality, high maternal deaths from unsafe abortion.
Let's talk about his allusion about the fact that it's not the decision of the woman, it's the opinion of the doctor that comes in.
There is no doctor.
Just a moment, Dr. Karanja.
There is no patient, there is no doctor who goes to fish for patients from their homes. Patients who have had issues are the ones who go to the hospital and present their case to the hospital, the medical professional. And now, if according to the medical professional, this is actually a serious matter, that she is going to injure her health and life, then you make the decision based on an informed decision, like what he had said, from history taking, physical examination, and any other laboratory or investigation that you want to do. You make the decision and make the judgment. There's no doctor who goes to the villages and make announcement that any woman who wants to have an abortion, come. And because of that, you want to
put up your own opinion. All right,
so the opinion is based on the demand that was presented to us and the health facilities, not us going around shopping for women who want to do it.
Dr.
And
Karanja,
if they do it, if they come to us and you can talk to them and convince them that yes, they can keep the pregnancy, well and good. But if the pregnancy is in, number one, I think I want to go back before you go to Karanja. The first thing is, as medical professionals, our role is to prevent unwanted pregnancy, whether from rape or even from normal life. Unwanted pregnancy through effective contraception, sexuality health education, which I know he does not believe in. He doesn't believe that women should be using contraceptives. He doesn't believe that women should be educated on how to avoid unnecessary pregnancies. But the most important point is, if abortion must happen, if it is inevitable, then that inevitability, that abortion that is a must, should be done safely without injuring the health and the life of the woman.
All right, Dr. Karanja, before we go to Evelyn to lay what the law really meant in that verdict.
There is something I would want my colleague here. He's a gynecologist. He's a professor of gynecology. I have no idea at all why he brings in religious things. And he knows who to talk to about religious things. He can go and talk to bishops or his cathists if you want to talk religion. I think he should concentrate on science. Number two, he can't doublespeak. He can't say that sometimes women have these psychological effects because of their religious indoctrination. Women are not that simple people. Women are actually the pillar of society, number one. They are on whom the life of society and the future is entrusted by the Maker. Women are not people who become manipulated by people, and therefore he must not say that these women you see who are developing psychological problems, it is because of religious convictions. It is not true. This is a scientific discussion, and let us discuss it like this.
So there's
abortion,
there's no mental complication as a result of abortion.
I'm saying medically myself. I don't know about your religion.
It's not there.
I don't know about
medical
your religion.
It's not there.
Daktari, you need to read. Now, but number two, I wanted to say this. The Kenyan constitution is clear. If the opinion of a trained professional is that a woman needs a diagnosis called abortion, and we must start from the definition of the word abortion. What is abortion? Abortion means the deliberate termination of a normal baby With
Point of correction. I
well,
think.
let me
No, no, no. I don't. No, 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 no.
Dr. Karanja, very briefly, please.
No.
Let's have Dr. Karanja finish
Abortion,
very, very briefly.
As a medical provider, as a gynecologist, we know abortion is any termination of pregnancy before viability. And they are divided into either induced abortion or spontaneous abortion.
All right, so that
both
brings
of
in-
them. Both of them. So it's not.
I'll let you finish.
Spontaneous.
When you are speaking,
women
I
who
will
have
let you
miscarriage.
All right, very briefly.
Women who have miscarriage have abortion. Women who have induced abortion have abortion.
Okay, so different definitions here of abortion.
So the fact is, it's not deliberate. A woman who once actually keeps the pregnancy and loses the pregnancy, you cannot say it's deliberate unless it's not deliberate abortion.
All right. Deliberate or not, let's bring in Evelyn now.
Let's talk about.
Just a moment, Dr. Karanja. I'll be coming back to you. Let's bring in Evelyn now. You've heard the men speak, and we've wanted men to be part of this conversation for a very long time. But really, at the end of the day, the verdict was passed by the High Court. What does that verdict mean for women in Kenya?
I think first, let me just go back a little bit to what Dr. Karanja had said, which I think needs to be clarified. That the Ministry of Health were not, like they had a good reason, or that they were not mad enough to just withdraw the guidelines. Now, this was a substantive issue in the case. The court reflected on the manner in which the Ministry of Health withdrew the guidelines. And the court came to a conclusion that the process of withdrawing those guidelines was unlawful, unconstitutional, and arbitrary. Because the Ministry of Health was saying that these guidelines were being misused. And the court was not convinced that there was no other way of dealing with any alleged misuse of the guidelines. And that, this was in 2013. 6 years down the road, there has been no guidelines. And the court then said that, in fact, that lacuna that was created by the lack of guidelines has affected women and girls' reproductive health rights. Now, going further, the court is charged with the mandate of interpreting the Constitution, the laws.
Right.
And the court has interpreted the law. We cannot sit here as people who are not in the judiciary and purport to know the law more than the court. If anybody is aggrieved, they will appeal. But at the moment, that is the decision of the court until it is reversed by any other court. Now, I think it's important to also say that this case that was taken to court, which is the subject matter of discussion, it did not ask for more than is in the Constitution. What we were demanding is implementation of what is in the Constitution.
Right.
Nothing more, nothing less. And so nobody had asked, we shouldn't create an impression that we were saying that women will walk into facilities and just say, give me an abortion. No.
It happens in so many other countries in the
Yes,
world,
it does.
including other countries like Ethiopia. It's happening in
Yes.
South Africa.
Yes.
But the question is, should it happen in Kenya with the moral foundation and the Constitution as it stands?
No, I think when we go to moral, we miss the point. This issue was a hot issue that was debated. The Constitution is the supreme law. Nothing, whether it's our tradition, culture, anything that goes against the Constitution is not allowed.
All right.
The Constitution is the pillar and is the basis upon which we must make our decisions. And as Professor Jaldesa explained, women, first of all, providers don't go around asking for women to come and seek services. But the provider, once the woman is before them, will make that decision. And give the woman all the scenarios. This is your condition. A termination would help in this way. And this may be whatever other effect. And the woman has all this, information. She ultimately makes the choice and say, yes, I do not want to die. I will have this termination. Or some women might say, I'd rather die than have a termination. But the provider is the one that makes that decision and then let the woman make the ultimate decision. Now, you asked what this means for women.
Absolutely, as we wind up this conversation.
Yes. This means that any woman who has been raped should, first of all, access post-rape care and should go to a facility, and with her provider, they will determine what is the best course for her. This means that providers can be trained should be trained so that they can increase their level of knowledge, including the nurses, the mid-level providers that we talked about, so that they are able to provide quality services to women.
Right.
And this means that the standards and guidelines have been reinstated and in place, and women should not be stigmatized when they go to access these services, and providers who have dedicated their life to providing reproductive health services should also not be stigmatized.
All right, and even as we wind up this conversation, Dr. Karanja, a big conversation here has been that life begins at conception. So at the end of the day, whether rape has occurred, sexual violence has occurred, and the mother has decided on abortion, there is an innocent life here that is involved, and that is where your argument is based on. Talk to us about that even as we wind up.
Even as we wind up, I want to correct some things. In Canada, you can kill a baby one day before the EDD. If the baby is expected to be born tomorrow, you can do an abortion today. I want that heard clearly, because I see Professor Jaldesa has not been reading well. And therefore, his diagnosis of an abortion is not when the baby cannot survive outside. Even a baby at 37, 36, 38 weeks can survive. And in Canada, they qualify for abortion. So abortion is not what he's misleading people to mean. Abortion actually is the deliberate killing of a baby. Termination of pregnancy with the specific aim of killing the baby. When that definition is put on the table, then abortion in Kenya and in America and in Canada becomes the same definition. I want to say that. Number two,
Your final comments, Dr.
Madam here says that when a raped lady, and there is nothing my spirit despises like rapists, and I think every resource in this country must be used to hunt them down and put them in and throw away the key. Kenyan women must not be touched, must not be injured, must not be harmed by anybody. After saying that, we must come to the crux of the matter. That when a woman is pregnant, from whichever way, no matter how dangerous way, we as a nation must develop the ethic of compassionately taking care of this woman and her baby till the baby is delivered. And to remember that that baby inside the woman is not the woman, is separate. If the mother develops any problem, she must be treated, and her baby also. But we must get out of our system in this country, and we do not need to copy any other country, that we must respect our people in whichever situation they exist. But above all, the abortion group sits on a very slippery ground where they appear like the advocates of women. We in the moral ambit are the defenders of women. Their health, their life, their social life, their spirituality depends on, that is what we fight for.
But you argue, Dr. Jame, Professor Jaldesa here should not be arguing on the basis of spirituality.
I think he should be. I think he should be. But above all, I would want Professor to accept one thing for the purposes of the students who may be listening, because he's a professor of gynecology, that in Canada you can abort a 37-week baby.
All right. Okay.
Therefore, his definition of abortion is wrong.
All right. So let's talk. Let's get away from the definition. I want your final comments, Professor Guyo. What does this verdict by the court mean now for the progressive movement towards SDG goals, reducing maternal deaths in the country?
I think I'd said earlier that this is a good opportunity, but once the court ruling has given, because from the word go, abortion was never an illegality in the country. The standards and guideline was just telling people what to do and when to do. Including, there were studies which were done which showed that women who present to hospitals with abortion have been looked at as criminals and they are neglected. And what the standards and guidelines show, people who have come with induced abortion, whether induced or whatever, spontaneous abortion, people look at them as criminals. They have done something sin, they have committed some terrible offense, and nobody cares about them.
And there is that argument, Professor, that life does begin at conception.
So, for me, I want to look at the woman who's carrying the pregnancy and who has had the misfortune of having a miscarriage or whatever. They should be attended to promptly and taken with humane manner. So the purpose, and then the purpose of the standard and guidelines is how do you even prevent repeat abortions? Because that's one of the key chapters in the standards and guidelines. It's not actually how to procure an abortion, it's how to prevent and save abortion.
All right.
That's the purpose. And therefore, the standards and guidelines are there. It should be something which is disseminated all over to all health facilities, and people should be using it freely without any fear.
All right. Let's have your final comments, Evelyn, as we wind up.
Yes, you rightly say that the
only small point. When internationally, according to the World Health Organization, globally, abortion has its definition. Anything that happens after the baby is said to be viable, which is beyond 20 weeks or 22 weeks, beyond 22 weeks is infanticide.
All right.
If people do that one in Canada, they're killing babies, not abortion.
All right. Evelyn, final comments, please.
You rightly say that the Constitution provides that life begins at conception. But the Constitution also provides that that life can be terminated if the pregnancy endangers the life or health of the woman, or in case of emergency, or if the rape, as a result of rape, the woman's health is in danger. Now, we can all have our views, our religious beliefs, our cultural beliefs, or whatever. But in the end, we must remember that the law is settled. The Constitution is very, very clear. We can hold our separate views, but the Constitution is the supreme law of the land. And we need to allow the Ministry of Health and the counties to implement the Constitution and the law without unduly intimidating them into, actions such as the one that they took, because we are, there are certain people or class that feel that they are more powerful and have that much influence.
All right.
And by the way, just for your information, when we did the standards and guidelines, we worked with my brother here. He contributed many information to those standards and guidelines. It's just that there are certain small components that they do not believe in.
All right, gentlemen, we have to wind up, unfortunately, on the basis of time. It is a debate I understand that the country will continue engaging in, but the verdict has been given, and until there is an appeal, that is what stands. Many thanks for speaking to us. Professor Jaldesa Guyo here, who is a practicing obstetrician. We also have Evelyn Opondo from the Center for Reproductive Rights, and Dr. Stephen Karanja. Many thanks for your time. We're asking you this morning whether you support the reintroduction of those guidelines on safe abortion as ordered by the High Court. When we come back, I will be reading some of your thoughts and comments. Let's take a short break here on News Center.